Join with computer audio, but it's got the.
Yeah, you're good. Mr. Brown, we want to challenge that to grow.
What?
Mr. Brown.
Is he on there?
Mr. Brown, can you hear me, sir?
Can you hear me, Judge?
Yes, sir. Would you mind slipping on a tie and jacket for me before we begin? We're streaming this.
Sure, I'm sorry. Most of this is, give me a second to go drag it out of my car, okay? I'll be right back.
Yes, sir.
Oh, he's back. Sorry, Judge.
All right, thank you, Mr. Brown. Sorry to cause a delay. I just be very consistent and get a good policy going. All right.
Not a problem.
All right, this is a cause number 20-130 J&L versus Thayer and L&L Line Services. And let the record reflect that Mr. Sanders, counsel for plaintiff, along with Mr. Schmidt, are present. Mr. Sanders is appearing online via Zoom. Mr. Schmidt's appearing in person in the 294th court. Let the record also reflect that Mr. Leister, counsel for Thayer and L&L, is appearing via Zoom, and Mr. Brown for interveners, Development Oil, appearing online via Zoom. I believe that we're here today on the plaintiff's motion for to compel discovery. Is that correct? Mr. Sanders?
That's correct, Your Honor.
And was there a separate motion to compel discovery, or is this based on the plaintiff's motion for expedited discovery?
No, there's a separate motion that we filed, Your Honor, to compel discovery that is the result of their objections and what little documents they provided in response to our discovery requests.
Hey, Mr. Sanders, can you tell me when you filed that motion? Because I'm not being able to find it in the clerk's file.
We filed it, I believe it was August 17th.
Mr. Schmidt, I don't suppose you have a copy of it. I don't see it. On 17th, I see a couple of filings, order extending TRO, proposed order granting application for temporary injunction, proposed order for temporary injunction.
All right, Judge, it was the 21st.
Yeah. I show the 21st. I do not have a copy of the original motion to compel discovery. I got left out of the file this around.
Mr. Leister, did you get served on that? Did you get served with a copy of that motion? Oh, Mr. Leister, you're muted. You have to unmute yourself.
Is that better, Your Honor? I apologize.
Oh, yes, sir. Much better. Yes, sir. Did you get a copy of that motion?
Your Honor, I have one that has a certificate of service dated August 21st, but I don't have a file marked copy. So I don't know if that's the issue or what. I mean, the one that I have does not have a file mark on it.
Okay. I don't show that it has been filed with the court. Mr. Leister, any objection to moving forward on that today?
Your Honor, I want to be sure that the court does have the response we filed to it yesterday.
I have no filings from yesterday. I'll tell you what, let me check your file, maybe send it to me rather than just filing it. That's very possible.
And I have my paralegal looking to confirm that the filing was accepted by the district clerk. She's very conscientious. If it hadn't, I would have heard about it.
You know, I've been in my e-file today and I have not seen that. But let me double check.
My paralegal is telling me that she called the district clerk and for some reason the filing wasn't accepted because the file was with you, Judge.
Okay. Yes, I think I found it now. Okay, and Mr. Leister, let me see if I've got in my e-file. I have four things. Plaintiff's motion to compel. I have it twice. Plaintiff's supplement to motion to compel and amended proposed order. Plaintiff's motion to compel. I don't have the response, at least not to me. If it was filed yesterday, there's a chance that the clerks haven't processed it and sent it to me. But okay, so it looks like we're ready to go then. So I'll, if I don't have it, Mr. Leister, I'll make sure that I get it before I roll. Okay.
Judge, I have a copy of their file.
You have a copy of Mr. Leister's response?
Of their response without, I believe there might have been some exhibits attached that I don't have, but I do have the actual response.
Yeah, if you wouldn't mind if I could do that.
It's both sides of the page.
All right. Am I free to use this for note taking?
Yes, sir.
All All right, Mr. Sanders, go ahead.
Your Honor, this is a motion to compel written discovery in the form of responses to requests for production or documents in response to requests for production. You'll recall that you signed a temporary restraining order in this case on July 31st to primarily to stop a foreclosure on some real property. The same day you granted a motion for expedited discovery. The defendants have never sought any relief from that order. They did respond to the requests with numerous objections, primarily based upon their claim that everything's irrelevant because of their pending motion to compel arbitration. We were there for a hearing on a motion on the temporary injunction on August 13th. And on that day, after some discussion between the parties, we agreed to extend the temporary restraining order, go to mediation on September 11th. If we are unable to settle at mediation, then we are going to have the temporary injunction hearing September 13th and September 23rd. And then the motion to compel arbitration, which was originally set for written submission on August 16th, has been reset for written submission on October 12th. After the injunction hearing, I followed up with opposing counsel. I sent him an email raising my problems with the objections to the discovery responses, also the fact that they were very limited in the documents they produced and that the documents had redactions in them. I did not get a response from him. I followed up with a phone call. I later was told that the day I called that he had been out for a medical procedure, but in any event, I never got any response to my email, which I'd sent a few days before that. So we filed our motion to compel discovery. This was originally set for August 26th. It was reset to today at the request of Mr. Leister. The discovery dispute does center around essentially their argument that the requests are not relevant and not reasonably calculated to lead to the discovery of admissible evidence because of their pending motion for arbitration. And there's two reasons why they're wrong on that. First, we have a temporary injunction hearing set for September 23rd. That the temporary injunction relates to attempted foreclosure under promissory notes and deeds of trust and security agreements that do not contain any arbitration clause. Secondly, the requested discovery is relevant to what we're going to put forward as our defense to the arbitration clause, which is unconscionability. And granted, that is a high burden to meet, but I think this is the case where it will be met. There's no question that Lance Thayer was the chief restructuring officer of J&L Utility Service Company starting on March 10th. Less than a month and a half later, the chief restructuring officer, who owes a fiduciary duty to the company, buys virtually all the assets of the company through another entity that he owns personally. So we have two reasons to have this discovery now. Their cases correctly point out that pre-arbitration discovery should be limited and that it should only occur if the party seeking the discovery proposes a colorable basis to show that the discovery relates to a defense to the arbitration. We've done that here. We have stated we're going to assert unconscionability, and this discovery is relevant to it. This is all to show that this is one big breach of fiduciary duty on the part of Mr. Leister. The cases that, Mr. Thayer, I apologize, counsel, by Mr. Thayer. We also have the unique position here of it's not just a pending arbitration motion. We do have a pending temporary injunction motion. And I don't know of any case that says if there's also a pending temporary injunction, you still don't get any discovery if it's necessary for the temporary injunction. And Your Honor, the facts of this case, the procedural history of this case is very similar, I believe, to a Tyler Court of Appeals case. It's and I provided a copy to Ms. Barker and with a copy to opposing counsel earlier today. It's In Re FC Holdings. It is 349 Southwest 3rd, 811. It's a 2011 case. It is a mandamus case. And you'll notice there, Your Honor, it was very similar. You've got there was discovery requests, then there was a motion to compel arbitration, an agreement to put off consideration of the motion to compel arbitration. The parties in that case had agreed to go forward with discovery. In this case, instead of a Rule 11 agreement to go for discovery, we have the court's order granting expedited discovery that is over a month old. They never sought relief from that order. If they thought that it should be shut down because of their arbitration, they should have come and sought relief from that order. They did agree to put off the pending, the motion for arbitration. And in the FC Holdings case, the court agreed, or the court found that the trial court did not abuse its discretion in allowing that discovery to go forward, and in fact, ruling on a motion to compel and a motion for sanctions. We didn't file a motion for sanctions. We didn't ask for them. We could have, but I just don't do that on a first discovery dispute. But we did file a motion to compel. And I think that this case is about as close as you're going to get procedurally to this case. They even had an agreement to go to mediation, and the mediation went forward and was unsuccessful. We're not asking for a lot of documents. We're talking about the starting point is March 1st of this year. The defendants in their response ignore the fact that we provided evidence that there was another bank account that J&L Utility Service Company had, and the defendants didn't produce any of that discovery or any of those statements. Their other defense to this motion is that we just want it before the mediation so that we can try to retrade the deal. And that argument ignores the fact that we sought this discovery long before there was any discussion of mediation. So we ask that you grant this motion and order them to produce the documents as requested. It's only 14 requests for production, and produce them in complete form and in unredacted form.
Thank you, Mr. Sanders. Mr. Leisler.
Yes, Your Honor. Let me kind of try to clear up a couple of potential misconceptions that you might have come away with from Mr. Sanders' presentation. There's a timeline that is important to keep in mind in this case. Mr. Sanders, I think, alluded to a portion of that, and let me see if I can explain. Mr. Thayer was the chief restructuring officer for this company for a period of time beginning in March and that ended on April 20 of 2020. If he had a fiduciary duty, and it ended on April 20 of 2020 because that's when the contract for sale to purchase this company was executed, and that's when this company was sold by J&L Utility Service and the Boyds to Mr. Thayer's company, L&L. That date is important. And so in responding to the discovery requests, my client did produce documents between when he became the chief restructuring officer and the date of sale of the company. In other words, if he was going to breach his fiduciary duty, he could only do so during the time he was the chief restructuring officer. From the point in time after he had acquired the company and the Boyds were no longer involved in the company, didn't own the company anymore, the company had been sold to L&L, there could be no breach of fiduciary duty. So from that standpoint, documents were produced for the relevant time period involved, which was the date in March when Mr. Thayer became the chief restructuring officer through April 20 of 2020. And so what I believe Mr. Sanders may be referring to as it relates to there were redactions on the documents, as the court might imagine, if there's a bank statement that has dates on it and transactions on it that take place after April 20 of 2020, then those are not relevant to the inquiry in question. And that's exactly why and how those were redacted. The bigger issue deals with the situation where we have an arbitration clause. And in our response, we set forth that arbitration clause in its entirety, and it's very broad. Basically says that any dispute arising out of, in connection with, or in relation to the interpretation, performance, or breach of this agreement shall be resolved by final and binding arbitration conducted in Dallas County, Texas, under governed by the Federal Arbitration Act and governed by the JAMS streamlined arbitration rules and procedures. We filed a motion to compel arbitration, and Mr. Sanders is correct that is going to be set for hearing by submission at a date, I believe now in October. The Texas Supreme Court has ruled on this. We set forth in our response that was filed the applicable case law, starting with In Re Houston Pipeline. And what it says is that when you have an arbitration decision pending, that the discovery is limited to gathering information about the scope of the arbitration agreement or a defense to it, and discovery on the merits of the underlying controversy is not allowed. Mr. Sanders' client's discovery, as it relates to things taking place after April 20 of 2020, frankly goes to discovery on the merits. When you get down to the issue of what transpired and when it transpired, all of his claims, frankly, or all of his clients' claims, frankly, center on the issues that took place prior to April 20 of 2020. I mean, claims that there was a fraud that took place. Well, that was a fraud that took place prior to the contract for sale. That there's a breach of that our clients had breached their agreement related to this contract for sale, which is going to be governed by the arbitration agreement. Breach of fiduciary duty against Mr. Thayer for the time he was the chief restructuring officer up to and until the company was sold on April 20 of 2020. Asked for an accounting during that exact same time period. Those are the claims and causes of action, and they all relate to the time period leading up to and through April 20 of 2020. Now his clients do ask for a temporary restraining order, which this court entered. And the temporary restraining order deals with the pending foreclosure sale, which the court entered a TRO and prevented from going forward. Since that point in time, I've provided to Mr. Sanders the documentation that reflects that my client, in fact, does own the notes, does own the deeds of trust and other security interests, the transfer, the assignment, and the sale of all of those. So he's been provided with that documentation as well. This case that was cited by Mr. Sanders, when you read it really doesn't have any bearing whatsoever. In fact, it in fact tracks the Texas Supreme Court case that I've cited to you. And what it says is it says that pre-arbitration discovery is available if the trial court lacks sufficient information regarding the scope of an arbitration provision or other issues of arbitrability. However, this is not an authorization to order discovery on the merits in the underlying controversy. Mr. Sanders cited this case in claiming and contending that it is analogous or similar to the case that we have before Your Honor. But when you dig into it, and I'm looking on page 5 of the document that was sent to you, what it points out is that the parties entered into a Rule 11 agreement regarding the production of discovery. No such Rule 11 agreement was entered into here. And the gripe there was that the party producing the documentation had failed to properly organize the documents as they were being produced, i.e., organize them as they're kept in the regular course of business, or by request for production number. And so the court went ahead and said, hey, since the parties have entered into a Rule 11 agreement, we're going to enforce that Rule 11 agreement, and that doesn't mean they skip out on the rules in terms of complying with the manner in which documents are to be produced. In reality, in this particular case, the documents related to what could be potentially the scope of arbitrability have been produced, because those documents have been produced that go through the date in question, which is April 20 of 2020. In addition, the documents related to my client's acquisition, ownership, assignment of the promissory notes, the security instruments, the deeds and trust as it relates to these particular notes, they've also been produced, Mr. Sanders. There's simply nothing else that is required in terms of my client being obligated to produce prior to either the mediation, or for that matter, the ultimate hearing if we go forward on a temporary injunction, which I understand is going to take place prior to the submission. And my client has simply complied with everything that they're obligated to comply with. Mr. Sanders wants to make a big deal about the fact that the court allowed for expedited discovery to take place. However, I don't think he seriously contends that means that my client somehow gives up his rights to object, or gives up his rights to insist that the production comply with the law as it relates to what happens when you have a pending arbitration motion. I don't think the court intended, when it allowed for expedited discovery, to strip my client of its rights to object if it thought that an objection was required or was necessary, and to produce the documents that it believed were relevant to the dispute, given the fact that there is an arbitration clause that we believe governs the majority, if not all, of these disputes, Your Honor. So for that reason, we would request that the motion to compel, along with the supplement, be denied in its entirety.
Brown, I'm assuming that you really don't have a dog in this fight just yet.
I really don't, Your Honor. I'm very interested in observing and seeing what documents are produced and things that relate to my client, who will represent to the court the fuel that we delivered was delivered prior to the sale date that they have referenced, but we were never paid for that fuel by either party. It's my understanding that the agreement included some indemnity provisions that all existing creditors in the position of people like mine would be paid by somebody, and I'm not sure exactly who, but we do observe with interest the assets of the former business that we sold to and what happened to them. And if in fact there was a foreclosure on other documents that was going to cut off all liens in connection with this case, we're very much interested in what happens in connection with that and want to see what happened to the assets of the company. But we have no pending discovery outstanding at this time, other than disclosure that's been requested of both sides.
Thank you, Mr. Brown. Mr. Sanders, would you agree with Mr. Leister that his client has produced responses to the discovery prior to what he contends to be the important date of April 20th?
No, Your Honor.
The discovery you're really looking for, is it that discovery that is after that proposed date?
No, Your Honor. One, and this, Mr. Leister did not mention this at all during his discussion or in his response. There's another bank account out there that they didn't produce the statements on. That's one. The statements they did produce, they were incomplete. There were pages missing, and they were redacted. And this, well, it's not relevant after April 20th. I mean, you know how bank statements work. Just because you cut something off on April 20th doesn't mean it doesn't reflect transactions that occurred before April 20th. There's nothing super secret in these documents that needs to be redacted. And in fact, we have a confidentiality order in place to protect those documents. So as for that argument, the before April 20th is only relevant argument, they're still deficient in their discovery responses. As for the after, again, it's relevant to the issue of the temporary injunction and this alleged purchase of the notes that occurred after April 20th. And again, the foreclosure is based upon notes that don't have any kind of arbitration clause in them. So, I mean, we're not talking about a vast amount of documents. We're talking about essentially 6 months worth of bank statements from 4 entities. That's not in any way onerous. And as for the FC Holdings case, again, yes, we didn't have an agreement to do discovery, but the fact of the matter is the defendants sat on their hands and did not file for any relief from the court's order granting expedited discovery. So once that happened, once they did not do that, then we just have to look at the objections and whether or not the information is relevant or reasonably calculated to lead to the discovery of admissible evidence on one of 2 things, either the injunction or the unconscionability of the arbitration clause.
Your Honor, may I briefly respond?
Yes, sir.
All right. Your Honor, I in terms of any bank account that Mr. Sanders contends that no records were produced prior to April 20 of 2020, if he will get me the bank and the account number, I will be happy to get that information to him. And if there are pages missing, I will be out of the bank documents that have been produced, I'll be happy to produce those. I just need to know which bank accounts he believes there's pages missing, and I'll either produce those or I will certify that there are no other documents prior to April 20 of 2020. The other argument I heard him make was documents related to my client's purchase of the bank notes and security instruments and that kind of thing. Someone else handled those, but if documents reflecting the consideration that was purchased, i.e., in fact, the documents that I have produced to him have, in fact, they recite how much was paid for them. So I'm not sure what else it is he claims he needs. But if he wants a copy of a canceled check or a wire or something to that effect, I'm happy to get that as well. As it relates to anything after April 20 of 2020, I stand on the position that I've previously raised with the court, and that is that has no bearing as it relates to the interpretation, the enforcement of the arbitration clause, because that took place after the fact, and we go from there. So, with that, Your Honor, that's all I have to add.
May I briefly respond, Your Honor? Very briefly. 2 points, Your Honor. One, I think where the money that was allegedly paid to, quote, buy the notes, that is relevant to the temporary injunction hearing. And secondly, for Mr. Leister to now say, oh, well, if there's another bank account, I'll give it to you. I raised that issue in an email. I raised it in our motion, and I didn't ever hear anything about it. They know we stated in our motion that it was at the First National Bank of Gilmer. Mr. Thayer was the chief restructuring officer of the company. He has to know what bank accounts that we're talking about, especially when we say First National Bank of Gilmer. The fact that they withheld that document, those documents alone shows what's going on here, and that is they are trying to hide something.
Your Honor, I'm looking at his motion right here, and I don't see a reference in the motion to a bank account at the First National Bank of Thayer. In all candor,
It's in Ms. Boyd's declaration, and it's the First National Bank of Gilmer, not Thayer. I hope Mr. Thayer hasn't taken over the poor people of Gilmer.
I don't think you have to worry about that. But if there's and there are multiple bank accounts, so if you give me a bank account number, I'd be happy to do that. Again, if that's the issue, I can certainly get that issue resolved and taken care of. If there's another bank account at the Bank of Gilmer, I just need to know which one it may be.
And the fact that I'm only hearing this now, Your Honor, is exactly why we need an order.
All right, then what I'm going to do is I'm going to review Mr. Leister's response. I'm going to review the Houston pipeline case, and I'm going to go back and review, because I haven't seen your motion, understand the arguments you're making. I'm going to go back and review that. What I'll do is I will render a ruling tomorrow, and I will have that order signed or not signed, and I will communicate that to the parties. My coordinator will reach out and let you know what my decision is. I'll either sign it and grant it or deny it.
All right, thank you, Your Honor.
Okay. Is there anything further, gentlemen?
No, Your Honor.
Not for me, Your Honor.
All right, thank you.
Nothing from us.
You're welcome. Yes, thank you, Mr. Brown. All right, so we'll be adjourned in this matter, and I will have my coordinator be in contact with you tomorrow.
Thank you, Your Honor.
Your Honor.